Hello, we're just going to give everybody a minute or two to join. Okay, hello everybody. Welcome to the North Hartford Promise Zone Spring Virtual Series Housing and Renters' Rights event with Greater Hartford Legal Aid. This event is going to be running from 6 to 7 p.m. today, May 27th, and is the final event of our spring virtual series. Please look forward to our summer virtual event series in July, and also be sure to follow the North Hartford Promise Zone's Facebook, Twitter, YouTube channel, and Instagram for more information on these events coming up, as well as others. The links to those are going to be posted in the chat, and the NHPZ Spring Virtual Series is a follow-up to our winter webinar series. And if you miss any of those, please check out the NHPZ Facebook page for the recorded videos. Today, we are super happy to welcome Cecil Thomas, an attorney with Greater Hartford Legal Aid. And if you have any questions for the speaker, feel free to ask in the chat or in the Facebook comments at any time. We will be sure to address them during our Q&A session. All right, you can begin whenever you're ready, Cecil.
Thank you, Anika, and it's a pleasure to be able to give this presentation to all of you on renters' rights during the COVID-19 pandemic. This has been an interesting time for all of us that work in this area, in particular for renters. The COVID-19 pandemic has had some significant impact on economic stability, particularly for tenants at this difficult time. And at the same time, there have also been some really robust interventions legally and in the form of rental assistance programs that are currently available to assist tenants who may be struggling. This presentation will cover the various moratoriums that are in effect right now, both the Connecticut moratorium as well as the CDC moratorium that was enacted federally. Additionally, we'll talk a little bit about the different rental assistance programs that are currently available and open to tenants to apply. And finally, we'll do a little bit of presentation on some common tenant rights issues, questions that come up during the pandemic. And then we'll leave time for questions. So certainly happy to answer those as they may arise at the end of the presentation. So just getting started out, this is an informational presentation. We'll be covering some legal matters. Today is May 27th, and so the information is certainly current as of today, May 27th. This information and the issues that I'm going to talk about do change fairly regularly as rental assistance programs are revised and the eviction moratoriums have been changed or go through further legal processes. And so this information is current as of today, but do encourage you, if you have specific situational questions about your own facts and circumstances, that you seek the advice of a lawyer. You'll see at the very end of this, there'll be some information on resources and contact information for statewide legal services, which, if you cannot afford an attorney, is a resource that will provide you with some advice and some review of your situation and may be able to refer you to an attorney if you cannot afford one. Let's get started out by talking about the Connecticut eviction process generally. So the eviction process ordinarily in Connecticut is a speedy process. The median time frame for an eviction in Connecticut is somewhere between 26 and 29 days. And so the cases do move quickly. The first document in your typical eviction process is a notice to quit, and we have an image on the right-hand side here of a typical notice to quit addressed to the tenants, listing the address, giving the tenant the date on which they have to leave or quit the premises. And during the pandemic, there have been some changes to the eviction process to create new bases upon which a landlord may bring an eviction, but also stopping many conventional types of evictions during the pendency or for the duration of the Connecticut moratorium. So if you get a notice to quit, which is that first document that the landlord will serve upon you or send to you as a tenant telling you of their intention to start an eviction, that is just the very start of a legal process. And that notice itself is not filed right away. It will be followed by further documents, the opportunity to go to court, file an appearance and an answer to tell the court where your defenses are, and then an opportunity to participate in, at this stage, virtual court appearances. First, for a mediation, that is an opportunity to work with the landlord and a court appointed mediator to see if you can explore a resolution of your case. And following that, if that resolution or mediation is unsuccessful, you'll have the opportunity for a trial before a judge, before a judgment will be entered. I say all of this to encourage you that if you receive a notice to quit, oftentimes people think that that means that they have to leave immediately or that they have to leave on that quit date. That's not, in fact, the case. The landlord does have to proceed with further court papers and processes, and you will have at least two opportunities to appear in court before the landlord can obtain a judgment against you. That being said, you do need to pay attention to the documents. You do need to file papers to protect your rights and make sure that you have those opportunities to participate in the virtual mediation. And if that virtual mediation fails, a trial before a judge if you choose to take your case in that direction. Only a state marshal with a court order called an execution may physically remove a tenant and their belongings. So at the very end of that court process that I described, the judge may, if the tenant has not won their case or if the landlord has won their case, the court may give a state marshal an order called an execution, giving that marshal permission to serve upon the tenant a notice with as little as 24 hours notice of a date and time on which the marshal will return to complete the eviction process. But again, there are many steps along the way before you get to that stage in the process. And so as a tenant, if you receive this very first notice to quit, don't ignore it, but wait for the following paperwork, pay attention to the instructions on those papers, and pay attention to what rights that you may have to protect yourself from the process advancing, if you can stop that, or additionally, if the court process continues, to make sure that you present your defenses and the appropriate paperwork to the court to protect your rights. If your landlord intends to pursue an eviction against you, you will get, after that notice to quit, something called a summons. That will have a list of instructions at the very front of the document telling you where you need to go to court and what you need to do. And then when you get to the court, if you're not able to, if you are representing yourself, you will be able to go to the clerk's office to seek some information about how to proceed. Court appearances and other papers can be filed electronically. But again, if you need assistance with this, contact Statewide Legal Services. The website is linked here, slsct.org. Also, make sure you go to the court clerk's office for the court that you've been assigned to if you need help completing and filing the paperwork that you need to do or need to complete to be able to protect your rights. Finally, there are a number of self-help materials, pamphlets, and information that's available to you at ctlawhelp.org. There is a video game that you can access there actually that can help you prepare for your court appearance, to tell you what to expect and how to present your case. And there's a wealth of resources available there for further information on the eviction process, as well as rights and defenses that you may have to protect yourself. As I indicated earlier, we've been in a unprecedented time in many ways, and one of the significant changes that has arisen during the pandemic is the Connecticut eviction moratorium. The Connecticut eviction moratorium was first ordered on April 10th, 2020, and prevents the start and filing of most new evictions through June 30th, 2021. However, a couple of exceptions there. One is that the eviction moratorium is really, in Connecticut, just a moratorium on the initiation and filing of most new evictions. That doesn't mean that the rent has been canceled or that your obligation to pay rent has stopped. In fact, rent is still due. And if you're able to make payments, even partial ones, you should make those payments, clearly mark them as rent, and keep proof of the payments that you've made. The Connecticut eviction moratorium also does not apply to the following situations, and this is important to pay attention to. Evictions that were started and filed before April 10th. So if you had a case that has been sitting in the court docket prior to April 10th of last year, 2020, that case is and can move forward. If you owe rent due on or before February 29th of 2020, so prior to the start of the pandemic in March of 2020, a court case may be pursued and advanced through the court processes again, for rent due on or before February 29th, 2020. Additionally, there's a new basis called serious non-payment of rent that has been created, which is by the moratorium, which is that if you owe more than 6 months rent due on or after March 1st, 2020, the landlord can issue a notice to quit, proceed to the court process to have you evicted. And so historically, prior to the Connecticut eviction moratorium, a landlord could evict you if you were a day late or a dollar short, as they said. But now the Connecticut moratorium increases that protection significantly, saying that a landlord can only pursue a claim of non-payment of rent if you have more than 6 months of rent due. So for tenants who are making partial payments and trying to stay ahead of that 6 month uh, window by which a landlord can bring an eviction. That's really important because so long as you can keep your balance under 6 months of rent, you should be able to protect yourself from the initiation of an eviction action. Additionally, if the tenant has created serious nuisance, that means conduct of this presents a serious or immediate danger to the health and safety of other landlords, use of the premises for the sale of drugs or other illegal criminal activity of a serious nature, um, uh, acts of violence or threats of violence against tenants or the landlord, or substantial and willful destruction of the premises. Those are bases upon which very serious type situations where a landlord can pursue an eviction if it arises to what is called serious nuisance. And finally, the last exception to the general rule that most evictions are not permitted in Connecticut, other than these ones that I've just discussed, are when the landlord has a good faith intention to occupy your dwelling unit as his own residence and your lease has expired. And again, the notice to quit that you receive is required to state one of these reasons. And if it does not match up with one of these reasons, that's not a proper basis for a landlord to evict you. If you think that there's an issue, call statewide legal services. Make sure you go to court. Make sure you protect your rights, and try to get an opportunity to be heard in front of a judge. There are a lot of myths out there about what's going on with the housing courts. Just to be very clear, Connecticut courts are processing evictions that are allowed to proceed under the exceptions to the Connecticut moratorium. They are entering default judgments. There are virtual remote mediations taking place on Microsoft Teams. And if you're a tenant, you really should not be ignoring court papers, filing deadlines, notices that you receive. It's important, again, that you follow through on those rights and do what you need to do. Let's say that you're in a situation where you are in the midst of an eviction and the landlord has initiated an eviction against you. There is an additional moratorium, the federal Centers for Disease Control moratorium, that is in effect through June 30th, 2021. So that date's coming up fast. And again, the Connecticut moratorium is currently set to expire on June 30th, 2021. The fate of what will happen thereafter is a little bit uncertain. But it is important to remember that the governor's emergency powers currently are set to expire on July 20th. And so, absent something else happening in the intervening period, both moratoriums are likely to end on June 30th. The Connecticut moratorium may be extended in some limited fashion to July 20th. But the end of these really important protections is coming up fast. And so, as a tenant, you should pay very close attention to that and be taking the steps that I'll talk about in the subsequent slides to protect your rights and interests. With the CDC moratorium, that can provide some additional protections if you have an eviction, but that is not an automatic moratorium like the Connecticut one is. You do have to complete and sign a declaration that's linked here, and you can find that on the CDC website. If you're eligible, that declaration needs to be completed, signed, and submitted to your landlord and possibly the court to be able to take advantage of the additional protections provided by the CDC moratorium. For the CDC moratorium to apply, you must again complete the declaration and send it to your landlord, and you must meet all of the requirements below. You must be able to say or show that you cannot pay your full rent or other housing payments because your household has lost income, lost work hours, experienced a layoff, or has very expensive out-of-pocket medical bills. Your total income for 2020 is less than $99,000 or $198,000 for the year if you're a joint household or filing jointly. You expect to earn no more than $99,000 or $198,000 for a joint return in 2021. You are not required to report any income for 2020 or you received an economic impact payment, a stimulus check. Additionally, you need to be able to show that you or the people in your household would likely become homeless or forced to live in someone else's home or in crowded situations if you are evicted. You are making best efforts to make timely partial payments as close to the full payment as your circumstances permit, accounting for the other essential expenses. This is really important because a lot of tenants have filed a CDC declaration, but then if they get into court, the court will ask you about your compliance with these requirements. And if you fail to make best efforts to make timely partial payments, you may not be able to receive the ultimate protection of the CDC moratorium. Finally, you have to make best efforts to apply for available government rental and housing assistance. Generally, you can call 211 to learn more about the available programs, and I'm going to talk about some of those programs in the following slides. How do you receive the CDC moratorium's protection? You're going to want to make sure you read that declaration form carefully. There are penalties or possible penalties and fines if you fail to complete the declaration form correctly or you fill it out with inaccurate or untrue information. So read that declaration form carefully, and if it requires you to do something like make partial payments to the rent within your ability, make sure you do that. Sign the declaration if the information is accurate. Give the declaration to your landlord. Keep a copy, obviously, of the dated and signed declaration and some proof that you delivered it to the landlord. And if you've got an open eviction case, make sure you file that with the court as well. So I said there's a number of really significant rental assistance programs open right now in Connecticut. And it's really important that you, if you're a tenant and you're behind on your rent, or you're a landlord and you have tenants who are behind on your rent, either landlord or tenant can initiate an application through the current major program that's opened up, Unite CT. But as a tenant in particular, again, those moratoriums are coming to an end fairly quickly. Both the Connecticut moratorium and the CDC moratorium are currently set to expire on June 30th. So this is the time to really get an application started. There have been some processing delays in those because of the number of applications the state is receiving. So get your application in. It can be done completely online. But if you need assistance, there's a number of ways to get technical assistance to complete an application. You can call the number listed here for help from the state for further assistance in preparing your application under Unite CT. There's Unite CT technology access support locations all over the state. So you can look at the website to identify the location that is closest to you. And you can also apply for an appointment at the Unite CT mobile bus, which is traveling around the state to offer people assistance in getting their applications submitted. The Unite CT mobile bus today, May 27th, was actually at CRT in Hartford, and it is in West Hartford next. And so check out the website, sign up for an appointment, get your application in with the documentation required so that you can try to avail yourself of the rental assistance that's available. Who is eligible for Unite CT? So you have to be a permanent primary residence in Connecticut. You need to demonstrate a need for assistance at the time of application, meaning you've qualified for unemployment, you've experienced a reduction in income, you have significant costs or experience of financial hardship due to COVID-19. This is a broad standard, so think about how you might show it with documentation or with your application materials. You have to be at risk of homelessness or housing instability. Oftentimes, that's really just that you have a rental arrearage, but if you have additional factors, you should be able to show those as part of your application. And additionally, you need to have a household income at or below 80% of the HUD area median income. If you're not sure if you qualify under that 80% standard, check out the Unite CT website. There is a map with area median incomes mapped out the limits based on your geographic location. What does the program provide? So the Unite CT program can provide arrearage assistance for rental arrears from March 13th, 2020 onwards. So if you've really been hit hard by the pandemic and you have a significant arrearage that has grown, get into the program. Now is the time to apply, and it can provide you with some significant assistance to bring yourself current. You can also receive prospective rental assistance of up to 3 months at a time based on your income qualifications. The total assistance period there, however, may not exceed 15 months, and the total rental assistance is capped at $10,000. But in certain extraordinary circumstances, even if you're over that $10,000 mark, apply, get into the program, because you may be able to file an appeal to seek a waiver of that in certain extraordinary cases where your situation has been particularly difficult. Additionally, there's utility assistance of up to $1,500 for an electricity bill that you may have accrued. This program is currently under revision, so these are the most current guidelines as I'm aware of them. But check the United CT website, because this program is being revised based on recent U.S. Treasury guidance that has changed some of the program guidance and program parameters. Additionally, there's a homelessness prevention program. This is the program really to try to apply for if you've already received a notice to quit. And so if you've received a notice to quit, you're currently in the eviction process, call 211 to apply for the homelessness prevention program as well. And under certain circumstances, you may actually be able to participate in both programs. This requires a notice to quit, so you can apply for this program if you have not received a notice to quit or are not in the eviction process. It is designed to target more at-risk populations. The assistance is capped at $8,000. That may be used for up to 6 months or 80% of your rental arrearage, whichever is less, subject to that $8,000 limit. And if there's something left on that balance may actually be available to you to be used for prospective rental obligations. Again, up to that $8,000 limit. It could be used for security deposit or utility assistance as well, but contact 211 to apply. There is also a program operated by Siri, Connecticut, that is for undocumented immigrants. I do want to highlight, though, that the Unite CT program will not require a social security number from tenants who apply. And so those both programs are both available regardless of your legal status here. And so I'd encourage you to apply for both if you're not sure. The program for undocumented immigrants available here does have some more, have quicker processing times. And so it may be able to get some smaller amounts of relief available quickly while you're waiting for Unite CT. And finally, there may be other local programs that are available to you to provide rental assistance. Call 211 to inquire further. We're going to shift a bit now to common questions about tenants' rights and common issues that have arisen during COVID-19. As tenants have been affected by the inability to pay rent or only pay partial rent, we're hearing a lot about landlords who are trying to engage in what we call self-help, trying to force tenants to leave the apartment, sometimes changing the locks, sometimes taking doors off of bedrooms. All of that behavior is illegal. A landlord is not required or not allowed legally to use self-help to try to remove a tenant from an apartment. The landlord is required to go through the official court process by serving a notice to quit. So lockouts, self-help, changing the locks, moving your stuff out of the unit without your permission, those things are not legal, not allowed, and only a judge can issue an eviction order, and only a marshal can enforce that order. And lockouts are a criminal offense. And so if you find yourself locked out of your apartment without your landlord having resorted to legal process, contact the police. Let them know. Let them show them proof that you reside in that apartment, and they should be able to assist you in regaining possession of your apartment. If the police are not able to allow you to regain possession of your apartment, you can bring a lockout, entry, and detainer action. You may also be able to gain access back to your unit, causing as little damage as possible. But I encourage you to contact the police to make sure they're available and present when you do that, and so can provide you some additional legal cover if you decide to try to let yourself back into your own unit. Other thing we see commonly is issues with repairs. This is pre-pandemic, post-pandemic, but certainly during the pandemic, this has become a primary concern. And so the eviction moratorium doesn't relieve a landlord of the obligation to make repairs. A landlord is required to comply with health and safety codes of the local municipality and must make the repairs necessary to keep your apartment in fit and habitable condition, to maintain common areas, provide, appliances that are provided by the landlord must be maintained. Those, common expectations under the law that the landlord is required to comply with, the landlord must continue to comply with. If you need a repair during this period of time, contact your landlord. I would try to prove that you contacted the landlord in different ways by keeping written evidence of that. If you're doing things by text message, keep those text messages. If you're contacting them by phone, keep a log or a record of your times of contact, what's discussed. And if you're unsuccessful in requesting repairs from the landlord, contact your town housing code, licenses and inspections in Hartford, health officials, and keep records of those contacts as well. If you're unsuccessful with all of those steps, you may be able to file something called a payment into court action. But for a payment into court action, you are generally required to have contacted the town municipal enforcement agency first, and to wait 21 days from that first contact before you can file a payment into court action. Other common questions are when can a landlord enter your unit? And this has become a particular concern during COVID-19 because obviously we are trying to keep people that may not be vaccinated, may have the potential to spread COVID-19 out of our homes as much as possible. General rule is that landlord cannot enter your unit without your permission, except in a case of emergency. Your landlord may enter your unit for other purposes, such as repairs, inspections, to show the unit to prospective renters, but the landlord must give reasonable notice and obtain your consent before that entry, unless this is an emergency situation like serious repair that's necessary, the unit's flooding, that sort of thing. A tenant also cannot unreasonably withhold permission to enter. And so this is an interesting issue that needs to be explored on a case by case basis. But if you have a legitimate basis to withhold that permission or to set certain limitations on your landlord's right to entry, be reasonable about those things. Make sure you're documenting your reasons. Try to offer reasonable alternatives that make you feel safe, that still allow the landlord to fulfill their obligations as imposed by law. If either the landlord misuses the right to enter or the tenant unreasonably withholds that permission, either the landlord or tenant have rights to go to court to try to stop that practice and seek damages. And again, you want to make sure that as a tenant, if you're refusing or delaying access to the unit, that you have some good faith reasons for doing so, and that you're documenting those in communications to your landlords and trying to set reasonable alternatives that allow the landlord to do what he needs to do while making you comfortable. Let's talk a little bit about additional rights for tenants with disabilities. And again, if you have a medical condition that limits your ability to enjoy your apartment unless changes are made, you have the right to ask for those changes paid for at your own expense to rules or policies or physical parts of your apartment if they're necessary because of your disability. Landlords can refuse those changes if they're unreasonable, and the landlord has the right to ask you to prove that you need those changes. They can't ask about your private medical information, so they're not entitled to know about your disability or what your diagnosis is. And so, in the case of COVID-19 diagnosis or something of that sort, if you needed some additional protections, changes to policies, you could ask for these in writing using as a reasonable accommodation to your medical condition or to your disability, and you may have to provide written verification from a medical provider of that connection between your request and your condition. But the landlord has no right in those circumstances to ever know what your condition is or the details of your diagnosis. They do have the right to have a medical provider prove that that is medically necessary to respond to your condition. And you may have to agree to reverse that physical change if, for example, you installed certain accommodations or physical changes, particular rails or railings physically in the apartment, flashing light doorbells. You may have to remove those before you move out and pay for those changes yourself. And there's a great tool here on the Connecticut Fair Housing Center's website that's linked here if you need to generate a reasonable accommodation letter. Finally, I mentioned earlier that I would close up my initial presentation before opening up for questions with some information on free legal assistance. And so there's currently free legal assistance available through the statewide intake line run by Statewide Legal Services. This is a great resource to call, although they are often overwhelmed with calls, so please be persistent and patient. That's 1-800-453-3320. They're open Monday through Friday, 9 to 12, and again from 1 to 2. And if you feel that you've experienced housing discrimination, there's an intake line at the Connecticut Fair Housing Center to report those instances of discrimination. Again, I want to highlight that there are a wealth of information, self help materials, pamphlets on your legal rights, on housing, and a number of other topics available at ctlawhelp.org. And so, if there are issues that are of interest to you, please visit those sites for further information. In closing, I want to just highlight again that given the changes that are coming down the pike in the Connecticut eviction moratorium, the CDC moratorium has been challenged in court. There is an appeal pending, but the state of that CDC moratorium is somewhat uncertain. And again, the Connecticut moratorium is set currently to expire on June 30th. And the outer limit of that moratorium, even if the governor agreed to extend it, is really only at this stage could only go to July 20th. So this is really not the time to sit on your rights as a tenant. Get into those housing assistance programs. Get your application in. Those may take a week or a few weeks to process. You're going to need to get your documentation lined up and uploaded through those systems. So now's the time to pursue these programs if you're not already doing so, because a payment of rent before those moratoriums lift that resolves your arrearage could really protect you from the start of an eviction as soon as these moratoriums are lifted. And again, there's a wealth of information and resources available to help you with those, accessing those programs and completing your application processes. There are housing counseling agencies throughout the state, including at multiple locations in Hartford, that can help you apply for Unite CT. Again, the SERI program is also available. And if you are concerned about your legal status in this country, that is a confidential program that is designed to keep your information confidential. And again, also the homelessness prevention program is really geared for individuals who currently have a notice to quit. So please take advantage of those programs now while you're still, in most cases, protected from an eviction, because once that eviction system opens up fully, sometime after June 30th, potentially after July 20th, those processes will move very fast, and you'll want to have an application in process for rental assistance that's available at this time. That is the end of my formal presentation. I appreciate your time and attention today, and I do want to open it up for, I'll turn it over to Jenna for the Q&A session.
Thank you so much, Cecil, for that wonderful presentation with a wealth of information. So I encourage you all to check out the resources that he's posted there, and we'll be posting links to that in the comments on our Facebook video as well as in the Zoom chat. So at this time, if you have any questions, I am monitoring the Facebook chat as well as the Zoom chat. So if you have questions, put those questions in the chat, and I will get to them as soon as possible. Also, feel free to DM me or the North Hartford Promise Zone Vista page, and we'll also answer your questions. I'll get us started, however, with a question about the eviction court process, which I know you talked about a little bit, Cecil, but what sort of things would help or hurt somebody's case when it comes to the eviction process? How long does that take?
So the eviction process has changed a bit because it's gone to a virtual format. So that's important to remember. You can participate by phone, but we've entered a new normal with access to a lot of different systems still being by virtual platforms, like in the court's case, Microsoft Teams. So I think the most important thing, first of all, is if you get that notice to quit or you get some indication that you have a court case pending, don't ignore it. Go to the court, make sure you file your appearance, seek legal assistance through statewide legal services. I think generally speaking, again, I've talked about the CDC moratorium. So if your case is about non-payment of rent, make sure you're following the CDC moratorium about making partial payments, really trying to keep yourself to show your good faith efforts to try to pay the rent. That is really important, even if there's a moratorium in place, because at some point these court processes will move forward. The average time for an eviction in Connecticut is pretty quick. It is designed to be an expedited process. I don't say that to scare anybody, just to make you aware that if you have an opportunity to resolve the underlying dispute between you and your landlord, if it's really just about unpaid rent, there's a lot of money in Connecticut, something in excess of $400 million in federal money is available in Connecticut to help tenants pay their rent. And so before ending up in the court process, if there's anything you can do to avoid that by getting into those rental assistance programs, you certainly should. Once you get into the court process, again, try to access legal representation through statewide legal services. If you're not able to do so, just pay very close attention to the papers that are served upon you, because oftentimes they will have very short windows to go to court and file the next set of papers. But when you do so, there are court clerks that are available. There's a wealth of information on CT Law Help to help you fill out the standard appearance and answer forms. There's often a misconception that you don't need to do anything when you get those court papers, that you're just going to get a court date. That's not true for the eviction process. You do need to go to court and tell the court that you, using a piece of paper called an appearance, that you intend to appear in the case, you want notice of the court hearings, and then you also need to tell the court what your answer is to the landlord's complaint, and your special defenses. And so there's a standard form that you can fill out for that that's available on the judicial website, and that the court clerks can make available to you or help you complete. But if you don't take those steps, the landlord will get a judgment against you by what they call default, meaning because you fail to appear or present a defense. And that's always the worst alternative. Going through the process will give you multiple opportunities to engage in mediation, and then, or one opportunity to engage in mediation, and then if that mediation opportunity fails, then you're going to have your opportunity for a day in front of your day in court, an opportunity to be heard in front of a judge. And so those things are really important opportunities to take advantage of. Finally, to the question of how to be best prepared or to present your best case, keep your documentation and make sure you have that documentation printed out. If you've made rent payments, make sure you can prove that you made those rent payments, either through rent receipts or through your own proof, money order stubs, that sort of thing. If you have problems with the apartment, the landlord hasn't been making repairs, make sure you take pictures and get those pictures printed or are available digitally so that you can file those with the court or show them to the court at the right juncture when you get a hearing in front of a judge. But the documentation piece and just making sure that you're putting that documentation forward to the best of your ability and showing the judge the full picture as evidenced by what's in writing, which is the best type of evidence, or what you can take a picture of. Those things can be really helpful in your case when you actually get to the point where you have to see a mediator, or if that mediation fails, where you have to have a trial in front of a judge.
Thanks so much for that answer. That's really helpful, and yeah, great to know. Getting a couple questions about when it would be smart to get a lawyer or seek legal advice. One example that we got was if you're having a feud with your roommate and your roommate won't pay the rent, should you seek legal help for that scenario?
I would generally say it's always a good idea when you think you're having a legal dispute to try to seek legal advice. I think it varies depending on whether you can afford to hire an attorney for that, or whether you need to seek legal advice, from a legal aid organization such as my own. And the route to do so would be to go through statewide legal services, which will screen you for intake or economic eligibility, screen you for income, and then if your case is appropriate, we'll refer you to a program. That being said, there are pre-pandemic, over 20,000 evictions are filed in Connecticut every year, and tenants are only represented in about 7% of those cases because there are not a lot of lawyers who engage in a regular basis in tenant defense. We're hoping to change that with some initiatives that are moving forward, such as the eviction right to counsel movement that really has seen some success this year in Connecticut. But my general response is if you think you have a legal dispute and you can try to hire a lawyer if you feel that's necessary, or even just to consult with a lawyer. You should do that. If you can't afford a lawyer, check out the information on ctlawhelp.org. Try to access that information because that is maintained up to date, covers a wealth of regular landlord-tenant issues like repairs, like how to pay the rent, what issues might arise, what to expect in the court process. If you're having a dispute with your roommate, again, there may be ways of resolving that outside the legal process if it's really about paying the rent. Ultimately, though, the dispute that you will have if your roommate refuses or fails to pay the rent is likely to be a non-payment of rent claim of some sort with your landlord. And so, again, the resources that I've shared previously are available to you to deal with that potential dispute.
Thank you. That's really helpful. Got another question. What are the circumstances that would let me break my lease? So you talked a lot about reasonable accommodation. At what point would you be in the right to break your lease and legally permitted to do so?
Really depends on the type of lease you have. So there are a variety of leases that you can have. You can have an oral lease, which is just based on your understanding with the landlord. You can have a written lease. If you have a written lease, oftentimes that written lease will discuss how you can break the lease. If you have what's called a month-to-month lease, and again, if you don't have something in writing and you generally pay your rent every month, the law presumes that you have a month-to-month lease. And so what that means is that each month is a new lease. What that also means is at the end of any 30-day period, if you just have an oral month-to-month lease, within that 30-day period, you can at any time tell your landlord, I'm leaving. Similarly, your landlord can, within that, at the end of any 30-day period, tell you, I no longer wish to rent to you, I'm terminating the lease. In which case, again, if you didn't leave voluntarily, your landlord would have to go through ordinarily the court process. If you have a written lease, this gets a little bit more complicated. So if you have a written lease, for example, for a 1-year term, oftentimes the lease itself will have provisions about what you need to do or when you can break the lease. And oftentimes you're not permitted to break the lease during the first year of the lease if you have signed a written 1-year lease. If, however, you do need to break your lease for certain situations out of your control, there's a couple things you want to check for. Your written lease may have what they call a stipulated damages clause or a liquidated damages clause or a penalty clause that says that you have to pay a set amount or you forfeit your security deposit if you break your lease early. It says none of those things. Ordinarily, if you break your lease early, you're responsible for whatever rent payments would become due for the remainder of your lease. However, your landlord is under an obligation to do what they call mitigate his harm. And so the landlord can't just sit there and say, well, you broke your lease early and I had 6 more months on that lease term. The landlord is required to make good faith efforts to re-rent that apartment immediately to try to mitigate their damages. And so what the consequences are of breaking your lease early are going to depend on the nature of your lease. Again, if it's a month-to-month lease, you really can end that at the end of any month. Just give your landlord notice. Written notice is best. If you have a written 1-year lease, you're going to want to pay attention to what the lease says about breaking it early. And if you have a written month-to-month lease, again, that probably oftentimes will require the tenant to give some advance written notice that they're terminating the lease at the end of the month.
That's helpful too. Let's see, I have another question that came in that is, I've already paid my security deposit, but my landlord is selling my unit. I'm not really sure where that's going, but what sort of things would you recommend in that scenario?
So if you're staying in your unit and the landlord is selling the unit, your landlord actually has the obligation to ensure that the security deposit is transferred to the new owner. And you may want to put something in writing just reminding your landlord of that, that your security deposit should be transferred. Because when you vacate, and there's actually a great pamphlet on this on CT Law Help. If you go to ctlawhelp.org and just Google or search within the site for security deposits, there's a great pamphlet on this. But the security deposit really doesn't belong to either the landlord or the tenant during the tenancy. It's supposed to be held in an escrow account. And then when you move out of the unit, the tenant is required to request the return of that security deposit in writing with a forwarding address where that security deposit can be returned to. What the law says in Connecticut is that 15 days after the date that that letter is sent, or 30 days after the tenant has moved out, whichever is later, the landlord is required to either return the full security deposit plus accrued interest, or can return a portion of the security deposit with an itemized statement stating what the security deposit was used for. And so, in the case where your landlord is selling the building, the landlord is required to transfer security deposits to the new owner. And when you moved out, you would request of that new owner the return of your security deposit. And that owner would be required to return your security deposit to you when you vacated. And so that's why it's really important between the landlord and the new owner that they work out the transfer of the security deposit. And again, just remember that in the best case scenario, when you vacate your apartment, you should request your return of your security deposit in writing, provide your forwarding address, make sure you keep a copy of that request, because if the landlord fails to return your security deposit, you may be able to sue them in small claims court or otherwise in Connecticut. May actually be able to seek double damages if they've truly not complied with that legal requirements for returning your security deposit.
Thank you. Yeah, I hope that answered the question. Got another question about, let's see, what if I am undocumented? Should I avoid being seen in court for an eviction notice or a notice to quit?
There's your legal status should have no bearing on the eviction. The court will never ask your status, and the landlord may try to introduce it or raise it, but that should be something that you object to, and that should be irrelevant to your case. That being said, we can't control what a landlord says or does. But I would never, ever encourage somebody to avoid a legal process that's ongoing where your rights are at issue because you're worried about your legal status. It should not be an issue in an eviction case, and the consequences of being evicted are obviously very severe. They can have some serious long term consequences. I will say, though, that if you're concerned about accrued rent, both the Unite CT program and the special program, rental assistance program that is currently open for undocumented individuals, those are open and available. Unite CT will not ask for your social security number, so you are eligible and do not need to share your legal status to apply for that program that can provide up to $10,000 in arrearage and prospective rental assistance. So if you're looking to avoid the court process because you're worried about that, do everything in your power to get into those rental assistance programs and to try to resolve, using those programs as well as any money that you have available to yourself, the underlying dispute between you and your landlord if it's about rent.
Thank you. I'm not seeing any more questions, so I think we can wrap it up. But thank you so much again, Cecil, for a wonderful presentation and for answering those questions so well and so thoroughly. If anyone watching this later or on our Facebook page has further questions that they would like to ask, feel free to email me and I can connect you with Cecil, or call one of these numbers that Cecil has provided here, and we'll get you plugged into the correct resources that you need. So again, thank you everyone for watching, and I'm going to hand the mic over to Anika, who will sign us out.
Thank you,
Thank
Jenna.
you, Jenna. Oh, yes. Thank you from both of us. All right. So that brings us to the end of our Q&A session. And that also brings us to the end of our housing and renters' rights event. Those were definitely some great questions. I think I've learned a lot. I'm definitely going to ask some of my friends who I know are, looking into apartments to check this out so they can keep that knowledge on hand. So big thank you to Cecil for all the helpful information today. Please look into the Greater Hartford Legal Aid to learn about the services that they provide, as well as the other resources mentioned during the presentation. We would really love to hear from you all, especially if you live in the North Hartford Promise Zone or are part of the Hartford community. And we'll be posting a link to our event survey in the Zoom chat and in the Facebook comments. And we ask everyone to please fill it out so we can put out more helpful resources and events like this one, and to learn more on how to serve the NHPZ better. Feel free to contact our Community Engagement Vista at jenna.vandonselaar@hartford.gov to learn more about the services that the City of Hartford or Envision Center provides. And we look forward to seeing you all at our summer virtual series. Otherwise, good night, everybody, and thank you so much once again.
Thank you, Anika, and thank you to both of you for putting this session together. It's been a pleasure to participate. Have a good night.
Thank you. Bye, everybody.